Today we're going to talk about initiating litigation. What steps do we need to take in order to get ready to draft a complaint and file a complaint? So the first thing we're going to talk about is information gathering and case development. Then we will start talking and reviewing pleadings and complaint writing, and then we will continue with complaint writing after spring break. So the first thing we want to talk about is the types of information that we are likely to be gathering in a litigation practice. So the first type of information is documentation, and depending on the type of case, this could be extensive. There will be information that we will have to wait until the complaint has been filed and we can do formal discovery to obtain. So frequently information that's in the control of opposing party, we have to use formal discovery to get that information. Sometimes to get information from non-parties that's relevant to the case, we will also have to wait and obtain that through formal discovery. But there's a lot of information we can get through our case development. Sometimes it's called informal discovery. And so we want to get as much of this as we can, as soon as we can, because it helps us get a better idea of what kind of case we have. So initially, our client comes in for the interview, we gather information from them, and then we start this process. And so our first tactic is usually, what information does client have, or what information does client have control over that we can obtain? If you are dealing with cases where you need to get clients' employment records, academic records, accounting records, medical records, just anything along those lines. Usually all we need is for client to sign a release form, and then we send the release form to the person or entity that actually has the records, and we are able to get them usually without any issues. Just keep in mind that if you are dealing with medical records, medical providers generally only accept their own release forms. They've always been very picky about it, but since HIPAA went into effect, they are even more cautious about how they will release records. So we tend to have generic release forms in our office, but for medical records, check with the medical provider first. For larger medical providers like hospitals, go to their website. They usually have a copy of the release form there that you can download and fill out, have clients sign it, and then send it off to get the records. There's also a whole area of public records that we can have access to. And in some cases, this will be a really good source of information. So on the federal level, there is a law that allows us to get these records. And on the state level, there is also a law that allows us to get these records. So let's talk federal first. The federal law is called Freedom of Information Act, and they talk about this in the textbook on page 184. The Freedom of Information Act, or FOIA, allows us to access most public records that are in possession of federal administrative agencies. So you want to get records from OSHA, you want to get records from FCC, just think any administrative agency. This is the tactic you would use to get that information. The first thing you always want to do, though, is check online, go to the agency's website, because sometimes there's information there that is helpful to us and we don't actually have to do a FOIA request. They also sometimes will have instructions for submitting a FOIA request, which just makes the process a little bit easier. Generally speaking, we can use any written request format, that they can't limit our ability to get the information because of the format that we use. But again, if you want to make sure it gets to the right place and is handled efficiently, check the websites. So FOIA, it is a great tool if you're ever looking to get information. Now on the state level, there is a much more recent law that is called Pennsylvania's Right to Know law. And I have attached a guide in D2L for your reference, although there's some information that I want you to make sure you are familiar with, and I will point that out to you in a minute. But this right to know law is fairly new. I think past 10, 12 years or so is when it went into effect. Prior to this, the assumption in Pennsylvania was public records are not accessible by the public. And if you wanted to get information, you frequently had to sue the agency or the government office in question in order to get those records. I know shortly after I moved here, there was a lawsuit where newspapers, including the Patriot News, was trying to get information regarding salaries of certain Penn State employees, one of which was Joe Paterno at the time, and they had to go to court to sue to get access to that information. And so it was very difficult, not just for journalists, but sometimes for us in the legal field to get information because the presumption was you can't get it. Pennsylvania's right to know law has changed that. So now the presumption is records are open unless they fall under an exception that is stated in the statute. And most of those exceptions that are stated in the statute are probably ones that you would just think common sense dictates you cannot get that information. Like you cannot get information about security systems of state buildings or infrastructure, certain infrastructure information or IT security information. You can't get information from personnel files of government employees. You may be able to get other information like their contact information and their salary, but you can't get their evaluations, you can't get medical records or anything like that. So this was a huge change in the law, and it's taken some years for everybody to kind of figure out how this works. But if you are handling a case and you want to get copies of inspection records from your municipality, or zoning records from your municipality or your county, you're going to use the right to know law. And if you look at the guide, the Pennsylvania Office of Open Records Guide in D2L, you will see it is very user-friendly. You can submit a written request in any format, so the law does not make it burdensome on a citizen to ask for this information. You do have to be specific in your request, and you do have to make sure you are asking for records. If you are just trying to get information like answers to questions, right to know law does not address that. So this is to get existing records. One of the nice things about this law, though, is once the request is made, the agency or the office has 5 days in which to respond to the request. And they basically have 3 options. They have to provide you with the requested records within 5 days, deny it because you're asking for information that falls under an exception and they must be specific, the reason for the denial, or they can invoke a 30-day extension of time. But within 5 working days, the requester should have some response from the agency or the office. So there are times when the information requested just takes longer than 5 days to get. I know when this law first went into effect, there were some issues, especially with smaller municipalities, where you had more community activists coming in and asking for information, which they were entitled to, but they did not have the manpower to always be able to collect that information within the 5 days. So they have this 30-day time frame. The information, there should be no charge for the information except for a reasonable copying cost and postage. So these offices and agencies should not be billing individuals for their time in gathering this information, but they can charge for reasonable copy costs and for postage, and they can require that information before they actually provide it. There is also an appeals process through the Office of Open Records. They are the administrative agency. And so if there are issues, if the individual who's requested the information is being denied or feels they're not getting what they're entitled to, or if the agency feels that they aren't supposed to release certain information, and they can appeal it through the administrative agency process and end up in Commonwealth Court if necessary. So, if you're doing certain types of cases, keep that in mind. These are really good resources of information that we can get fairly quickly and fairly inexpensively for our client. Okay, there's also other information that we can gather during this time that can be very helpful to us in developing our case. Photographs, videos, diagrams of whether it's somebody that we hire to do the diagrams or recreations, or if we do computerized recreations. There's the timelines, there's all sorts of case development software. Sorry about that. There's all sorts of case development software available that your firms may use, or they may outsource to gather that information. And then there is also physical evidence. We don't tend to have as much physical evidence in civil cases as we do in criminal cases. But I want to point out an important difference that everybody needs to be aware of, and that is the chain of custody. So in criminal cases, we're all pretty familiar with the fact that any evidence in a criminal case, it has to literally be accounted for every step of the way, from the scene of the crime to when it gets into court. So who has touched it, how it was touched, where it went. And we know that if there's any issues with it, that is one of the ways the defense attorney is going to challenge the evidence. In civil cases, we do have a concern with chain of custody, but it is not the same as criminal. It is not as stringent. So what our concern is with physical evidence in a civil case is we need a witness who can testify in court that that item of evidence, whatever it is in substantially the same condition now being offered into court as it was at the time of the event or transaction. So we do not have to account for the item every step of the way, but we need to have someone who can testify under oath that this item is in substantially the same condition as it was the time in question. So to give you an example, in a type of case where we don't usually deal with a huge amount of physical evidence, I had a custody case once. An opposing party wanted to offer the children's clothes into evidence as proof that my client did not send her children back to their dad wearing clean clothes. So they had the dirty clothes there. Dad's new wife was testifying, and she was asked about these clothes and when did the children arrive? What day was it when they were wearing these clothes? And is this how they looked at the day in question? And she could answer positively to all those questions, and then they were admitted into evidence. So even though I thought it was kind of a silly thing to offer into evidence because they were young kids and young kids get dirty, that's what they had to do to prove that these clothes were in substantially the same condition. So if you ever have a case like that where somebody brings you something physical that might be evidence, we need to have a witness who can testify to it in court. And as long as we can do that, then we can admit it into court. So it is different than criminal, so don't get them confused, but it is still important that we are confident it is in substantially the same condition. And in those cases, when the client or the witness gives us that information, gives us that item of evidence, we then keep it, and we keep it in a safe place in our office. So it does stay in substantially the same condition, and we can be confident what we're offering into evidence is, in fact, how it looked at the time in question.